looks like, all the way to defending evictions for failure to comply with code. And I think there's a little typo slide. It says I want a graphic clip art here. Okay. Let's fast forward a couple. Okay. Yep. So this, it's worth noting that both the TMC ordinance, the original July ordinance 1.95 and 1.100, there is a requirement that the landlord comply with its tenant protection laws. Both of them in turn cross-reference RCW 59.18.060, and that RCW in turn points to all applicable code. And so I do think Adam talked about a statement about having a city license. Having that certification that they're complying with the code, which actually I believe there's a city form for that, would be, I would say, a prerequisite to enforcing that eviction, which also means it's a defense to the tenant. And we talked about this earlier. If there is preponderance of the evidence, pictures, so forth, the courts may very well set that to a trial to resolve the contested issues of material fact. Anything you wanted to add on the code?
Let's see. No, I don't think so. Not with regard to that.
Okay.
Yeah.
So that's just a continuation of what I was just saying. So I think we can skip past that, but that's, I'm highlighting the word any because I do think that opens some avenues for tenant defense in terms of the building code and in terms of the rental code. Again, though, there should be some proof offered, and that might end up being kicked to trial because at the show cause hearing, that's not the place to decide contested issues of material fact.
Yeah, and it's when you're looking at those habitability issues, the RCW 15-18060 that Beverly was referring to, while the application is as broad as she says, any applicable code, there is a depth portion of that as well, and it talks about if the condition endangers or impairs the health safety of the tenant. So from the landlord's perspective, there may be a breach, but the landlord's analysis is going to be, well, how extensive is that breach? And does it reach the level of endangering or impairing the health or safety of the tenant?
Okay. Okay, so next slide, please. All right, so, oh, go ahead.
This is like the arbitrary kind of like whether it meets the standards or not. Like, where would you best just look at the like deciding metrics on what matches that criteria?
Yeah, so that's a little bit of a sliding scale, unfortunately. There's a case.
You don't have that right now. It's okay, but I'm just wondering,
Yeah.
there's always those issues.
Well, there's an older case. Anyone who's involved in landlord-tenant law knows it. It's Foysley v. Weinman. The site is 83 Washington 2nd, 22. Actually, I'll give this to you. But it really, in this one, the court really goes into habitability issues, and from the court's perspective in 1973, what those mean. And in a lot of the briefing I've seen involving this issue, this case is always cited. It's kind of a good starting point in determining legally what makes premises uninhabitable or habitable. So,
well, I think, and I would say that from the tenant's perspective, this does go beyond habitability as well. I would say from the tenant's side, if you have some evidence that whatever the code violation is violates the health or safety of the tenant can make that case, and then that would at least potentially get them past the show cause and have it set for trial prior to the issuance of the writ. And in terms of the evidence, again, I would say pictures, potentially if you have an expert, and most tenants, of course, can't hire experts, but if they did, or pointed to, say, a peer-reviewed article about whatever the condition is, I'm just sort of spitballing here, but you'd have to make that showing. But I would say that it goes beyond habitability necessarily. And you're talking about conditions that endanger health or safety.
I had a case with 2 of these electrical cover plates. Tenants broke them, but they had exposed wiring, and the commissioner found that could potentially impact the safety and health.
That's a good example, yeah. So the example was the electrical cover plates were broken and exposed wiring was present, and the commissioner made a finding that that could endanger health or safety. I think that's a good example because it doesn't necessarily affect, habitability per se, but it is a safety issue potentially.
Yeah, the safety is.
Yeah.
Does access to the guaranteed resources on the landlord or the building fall under safety? Like, for example, if a landlord decides to arbitrarily just say that the tenant can't use XYZ thing, and normally that would be like something that would be safety or other thing, would that, or that fall under the category of habitability?
So the question was if the landlord is, say, prohibiting the tenant from accessing some services
Yeah,
or
guaranteed
right.
contract with the building that you're renting from, for example, I don't know, the elevator, or like, I don't know, like what it would be, for example, if I've heard about can't use the internet or you can't use something, I don't know. They decide to just arbitrarily limit access because they're trying to punish them or something. Would that fall under safety issue potentially, and that be under this category or a different sort of like?
So and the question is whether access to arbitrary limitation, I would say, of access to certain amenities, the elevator. What else do you? Yeah, anything else guaranteed in the lease. What I would say there is that could potentially be a breach of the lease, right? So that the tenant might say that their lease was breached, but you'd still have to draw a health or safety nexus. So in the case of the elevator, my ears perked up because I'm thinking, oh, ADA, I'm thinking maybe someone who has trouble walking. So that potentially, but
what if, for example, online portals, even like payments online, and like say the person's handicapped or otherwise, and just in general, like they can't, not as mobile as a regular tenant, because the landlord is like limiting their access to the, you know what I mean? Do things on like you can't use your online portal to come into the office, but this person's like limited, they can't do it around town.
So that sounds like that might be a reasonable accommodation issue. Huh?
yeah, as opposed to a health or safety kind of
Yeah, so I'm
premises
wondering if
issue.
this falls under that.
Yeah, a different area, I would say. Yeah. Okay, next one. Oh, no, Dzaman. Okay. So I love this case from the tenant side, and I use it all the time. Well, or it's come up at least for me, and I've shared it with some of the friends on the tenant side. Dzaman versus Gowman was a 2021 case, and the reason why it's potentially really powerful from a tenant side is because it had the effect of prohibiting a writ of eviction. So that actually the tenant lost at the trial level big time. Not only were they evicted, but they also had to pay CR11 sanctions. And so this went up to the Court of Appeals. It's a published decision. And what the Court of Appeals said there was essentially that the landlord had to comply with the newer proclamation guidance, which required an affidavit, which was not the case when the landlord first brought the action. That was just a statement that they were intending to occupy, or that was rather than notice. All of a sudden, the second moratorium required an affidavit because the landlord did not reissue the notice with the proper affidavit. The Court of Appeals reversed the writ of eviction, reversed the sanctions. And I think this is important because it has, in my mind, it could potentially affect some Tacoma tenants under the Landlord Fairness Act, because if the original notice did not comply with the heightened requirements in the Landlord Fairness Code, or if there's code violations, for example, or the landlord hasn't provided proof that they have a business license in the city of Tacoma, potentially a writ of eviction issued without that compliance could be challenged under Dzaman versus Gowman. Now, that hasn't been tested yet, I will say, or at least not at any appellate authority, but it is at least a tool in the toolbox. And the reason why Dzaman went the way it did, because when I first read it, my initial instinct was, well, if the landlord's complying with the law in effect at the time, why is that not retroactive? Well, the court's decision in Dzaman versus Gowman is because the governor's proclamation also prohibited the landlord from enforcing the judicial order. So because you are turning to the court system for that writ, and because the proclamation was in effect at the time the writ was issued, or then the tenant was allowed to, the tenant could make the argument that the landlord needs to comply with new requirements. I think there's some support for that in the Landlord Fairness Code as well. And that has to do with the definition, two parts. The definition of eviction, I think, is broad enough to bring Dzaman into play, at least from the tenant side. It's an effort by the landlord to terminate or discontinue the tenancy through any means, including unlawful detainer, refusing to offer a new lease, or seeking a mutual termination agreement. So under that analysis, I do think you are talking about enforcement. So I do think that there is a potential avenue for a stay, or even to ask for dismissal or trial to resolve material issues from the tenant's side. I would also say that under Part 5, which is the miscellaneous provision, there is another section, Section 5 of Part 5, which states that any ambiguity in the chapter shall be construed in favor of the tenant. So as a result, I would say I would be looking for that from the tenant side protections to see if the original notices comply with the heightened requirements. And if they didn't, and if my client were facing an eviction, I would be briefing Dzaman. I would be making that argument. And whether or not it would be successful ultimately, again, this is too new. It hasn't been tested yet. But I do think that there is at least the potential to bring those claims. I think those claims are, I certainly don't think they violate Rule 11, because I think they're either arguments about what the law means or good faith extensions. And so I would say with all of that, the ultimate goal, I think, would be to reach mutually agreeable resolutions, because of course that's much faster than going to the Court of Appeals. But Adam, what's your